What makes a place actually good for holding arbitrations? To use this terminology, what is a good seat for arbitration? Not good in the sense of pleasant weather and decent coffee, though one does appreciate both. I mean really, structurally, legally good. The kind of place where parties with billions at stake would willingly entrust their disputes. Because here's the thing, anyone can claim to be an arbitration hub. It's rather like claiming to be a world-class city. Everyone says it, few can prove it. About a decade ago, the Chartered Institute of Arbitrators decided to do something about this. They created a framework, 10 principles, a checklist, if you will, for what separates the serious from the merely aspirational. They call them the London Principles, not because London has some monopoly on excellence, but because that's where they happened to be standing when they wrote them down. Now let me walk you through what they actually mean. When I cover them in order, it's just for mere convenience. All principles are important. And actually, some significant aspects may exist even beyond them. First is about the law. Does the jurisdiction have clear, modern arbitration legislation? Ideally, something based on the ancestral model law, the closest thing our field has to a common knowledge. When parties from Tokyo and Toronto and Sao Paulo sit down to arbitrate, they need confidence that the legal framework won't surprise them. Familiarity breeds trust. Obscurity breeds litigation about the litigation, which rather defeats the purpose. Second is the judiciary. This is where things get interesting and where many jurisdictions quietly fail. Under the New York Convention, the courts of an arbitral seat hold significant power. They're the final arbiters of an award's validity. What they decide tends to stick. So if your local judiciary views arbitration as an inconvenience, or worse, as competition to be undermined, you have a problem. The best seats have judges who understand arbitration, who respect party autonomy, who intervene when necessary and stay their hand when not. This isn't about legal knowledge, it's about judicial temperament. Third has to do with legal expertise. You need people, specifically a deep pool of local arbitrators, counsel, and the constellation of professionals that any serious arbitration practice requires. Even where international arbitrations are involved, local expertise remains essential. Fourth is education. Great arbitration seats don't just have expertise, they cultivate it. Universities teaching arbitration, professional bodies offering training, mentorship programs pairing experienced practitioners with those coming up. I heard something at a conference a few years ago that stayed with me. A former attorney general was speaking about diversity in international arbitration. And he made a point that applies far beyond its original context. He said it wasn't enough simply to have more people present. What mattered was meaningful participation, substantive involvement, rather than mere presence to satisfy some diversity requirement. This translates to any jurisdiction building its arbitration capacity. Diversity and inclusion begin with opportunity. They mature through mentorship and sustained support. Fifth deals with the right of representation. Parties must be free to choose their own representatives, whether from inside or outside the jurisdiction. Any restriction on this fundamentally undermines the flexibility that makes arbitration attractive in the first place. Sixth is a practical issue, accessibility and safety. Can people actually go there? Can they work without unreasonable visa constraints or other practical pressures? Are they safe? Is their documentation secure? These seem obvious, yet you'd be surprised how many otherwise promising jurisdictions stumble here. Seventh, what are the facilities like? hearing rooms, transcription services, document management, translation, the infrastructure of dispute resolution. Arbitration is ultimately a service, and services require logistics. Eighth, what is the level of ethics? Professional norms that embrace diverse legal and cultural traditions, clear standards governing the behavior of arbitrators and counsel. Trust depends on predictability, and predictability depends on shared ethical frameworks. Ninth is enforceability of agreements and awards. Adherence to international treaties, particularly the New York Convention. An arbitration agreement or an arbitral award are only as valuable as your ability to enforce them. A seat that produces awards the rest of the world won't recognize has rather missed the point. Finally, 10th is immunity of the decision makers. Arbitrators need protection from civil liability for good faith decisions. Without this, you won't attract quality arbitrators. It's a matter of risk management. In arbitration, reputation is a track record. It's doing things well again and again over time.